Next is Mr. Paul Gunter, Nuclear Information and Resource Service, NIRS.
Yeah, thank you. It's really a pleasure to be here at Howard University. Actually, we've been working with a number of environmental law clinics around the country. Rutgers Environmental Law Clinic up in Newark, New Jersey. We're currently there are attorneys in a relicensing case of the oldest nuclear power station in the country. We're also working with Turner Law Clinic at Emory College, Tulane Environmental Law Clinic. Certainly we'd like to open the discussions with Howard on how your folks can become engaged in grassroots advocacy work. We've been a grassroots advocacy organization on nuclear power, nuclear waste issues since 1978. I can tell you that there's a big concern right now. Obviously, energy is a central issue to reducing poverty worldwide. And at the same time, we have to recognize that, particularly with rapid climate change, that there are limits and that we need new solutions to address what has been an unabated growth through coal, oil, and nuclear. Today we're here to talk about the environmental justice issue. After more than a decade of activism by civil rights groups and environmental groups such as ours, and the publication of a host of reports showing minority communities suffer disproportionately from air, water, and hazardous waste pollution, President Bill Clinton, by executive order, made environmental justice a part of the federal review process. And at that time, that was supported by NRC Chairman, Nuclear Regulatory Commission Chairman Ivan Selin. But on April 24th, 2004, the U.S. Nuclear Regulatory Commission, which is charged with safety, security oversight of 104 U.S. nuclear power stations and the licensing of any new plants, declared that it was no longer legally bound to consider environmental justice in any of its licensing proceedings. In fact, I think that that's clearly represented by the, in Claiborne County, Mississippi, we, along with the Claiborne County NAACP, the Mississippi Sierra Club, and Public Citizen, intervened before the U.S. Nuclear Regulatory Commission to request a hearing on the permit for the proposed Grand Gulf II site. And when we began looking at the issue, our contentions were focused on safety, security, and much to our surprise, environmental justice. When we began to really look at the issue, as Mr. Espys has so eloquently pointed out, it was discovered that in 1986, the Mississippi State Legislature, and I don't believe they acted on their own, reallocated 70% of the property tax due Claiborne County that was to be assessed on the newly operational Grand Gulf Unit 1. Now, what strikes us as odd is that reallocation was based on kilowatt usage, and in fact, it's our assessment that the legislation was driven by tremendous cost overruns associated with the construction of what was known to be Grand Goof Unit 1, which had tremendous cost overruns and failure to meet time to completion, a situation that has been endemic to the nuclear power industry since its conception. And was only part of the $150 billion cost overrun that this industry occurred up until no new orders were placed in 1978. So we're looking at an all but moribund industry in this particular case sought refuge by racial discrimination against the people in Claiborne County. Now, what this means is that emergency planning, in context of our licensing challenge, to raise the issue of proposing to build a new nuclear power station when the emergency planning infrastructure, I mean, we went down to Bald Hill Road. I'm pleased to see that road is now intact, but for 3 years there was a washout